Good morning, everybody, and welcome on board again. We are going to resume our conference with the panel E, the contents of collective bargaining in the gig economy. And as you know, we are in Spain, but today our dear neighbors are going to talk. And the first neighbor is France. Marie-Cécile Escan-Bagnol from Lyon 2 University. She's an expert in this issue, particularly, and she's one of the fundators of the origin of this project as well. So we are delighted of having you here, Marie-Cécile. And the floor is yours.
Thank you very much. Perhaps you see me better like that. I'm very happy to be here in Santiago one time more. And I want to thank one more time José María and Yolanda and Tania and todos los equipajes todos los teams que nos han preparado este congreso. Good, so I have to speak in English. I want to speak in English, but perhaps sometime I will speak some words in Spanish. Perhaps we could have the PowerPoint, please? Yes, thank you very much. You say that I'm an expert, but I am not an expert in social protection. I have to say it immediately. But it's a very interesting topic, and I think that social protection is the Pacific revolution of 20th century. It's a great path for the humanity. The corner shop of the European social model, it's like said the EU institutions. But social protection, what does that mean? For whom and how? And that is the great challenge. Social protection is sure, it's for people because it's a human right, and it's not for AI and no algorithms. That's very important because if in the future all the workers are robots, robots don't need social protection, of course, but people will need always social protection. For that, this matter is very important. There is a need today to renew the rules and the functions for the future of workers and people. And the real question is, are all involved platform workers and various workers from gig economy in social protection scheme? To present this issue, I've done a quickly overview of this issue, and after we will speak about the difficulties with implementation, because that is the huge difficulties, and we will look for solutions. This question of social protection is present in many international standards. All along the 20th century, all the international organizations have stated on this matter. The International Declaration of Human Rights perhaps was the first one, Philadelphia Declaration, and of course the Great Convention from ILO in 1952. The recommendation in 2012. And like said Barbara Kreisel yesterday, the European Social Charter, and by the European Council too, the European Code of Social Security. So a lot at international level, but also at the European Union level, our fundamental provisions with the treaty, the Union founded on the values of respect for human dignity, freedom, democracy, equality, the rule of law, and respect for human rights. That is the European social model. The TFUE and the Charter of Fundamental Rights, the Title 4 about solidarity, social security, benefits and social services providing protection are concerned. And also the newer European Pillar of Social Rights, Chapter 3, Social Protection and Inclusion, with social protection, unemployment benefits, minimum income, health care, inclusion of people with disabilities. So we have a lot of instruments at the international level. All those standards mention adequate social, sometimes proper social protection. What does that mean? I found a definition by ILO, social protection or social security. That's important because those two notions really are synonymous at international level. Perhaps not at national level after, but at international level, yes, it's sure. Is a human right and is defined as the set of policies and programs designed to reduce and prevent poverty and vulnerability throughout the life cycle. Social protection includes benefits for children, families, maternity, unemployment, employment, injury, sickness, old age, disability. I put the last words on bold because it's linked with work and all workers. So the scope is very large. It's larger than the question of health and security at work. And it concerns all the life of people. But the difficulties is in the implementation, because when we are with international standards, we are very theoretical and we are in the will. But what about the realization? Difficulties with implementation, of course, because it's not only a social right, it's an economic right, so an expensive economic right. And to implement the will of social protection for all the people, we need to have funding and to have a huge organization. For this reason, and for cultural and historical reasons, each country has elaborated its own scheme. And that is one of the problems today in Europe. Coverage and funding differ from country to country, and perhaps it's difficult at the level of competence from EU institutions. So here here you have a board with perhaps it's a little caricatural, but you have the 4 grid schemes in Europe. And you can see that from some schemes, there is universality first, but financing by taxes. And in other cases, they are contributory, and it's very important, speaking about work, contributory of employment, by employment, and the finances is by social contributions. That is, I think, very important. Even that in the country where there are historically social contributions, today there are taxes too, and taxes have to contribute to the financing. So how to finance social protection for independent workers? That is the real matter, the real issue of today's. Platforms and global companies try to avoid their participation to social protection of the workers acting for them. In the schemes where the finances come from taxes, everyone participates to the finances, people and also resident legal entities, if they are resident in the countries. So those big platforms are resident in the countries where the taxes are lower. For that, I think that the new minimum taxes on global companies, the actual discussion or agreement for 7J or 20J could contribute to the financing of social protection. In the schemes of contributory, platforms escape their contribution by the obligation of the self-employed status. If they are self-employed, they can contribute for themselves. Yes, for themselves, sorry. But the platform hasn't to contribute because it's not the employer. So the statute is not only a problem of labor law, it's a huge problem of social protection for the contribution. They use only algorithms and haven't to contribute. And that is in the future very important for the financing. And so I think that they have to pay for AI, for that. And we will come back on that later. So perhaps it's time to have a reflection, to look on for solutions at the EU level. I didn't have a look on the schedule, so. One say that there is weak competence of EU law beyond fundamental principles. Perhaps it could be, it's not totally exact. But when, at the EU level, when we speak about social protection, immediately you hear about coordination and regulation. But the regulation of coordination is only for freedom of movement for workers. So it's not our matters today, because we are not speaking about freedom of movement. So the competence, the competence in social protection is a problem in the implementation. There are some articles in the TFEU, but the problem is that the adoption of directives in this issue must be taken at the unanimity. And the problem is more the unanimity than weak competencies. There is competence, but the problem of unanimity, it's a great obstacle. So, if the regulation can be a real solution, perhaps political will could be better rather than binding regulation. for that, for years, it's time for employment and social policies, the European Employment Strategy, then the open method of coordination, OMC. It produces guidelines, cooperation, good practices for convergent policies in Europe. And this convergence could conduct to universal social protection and perhaps equality between workers at national level, whatever their status. And I think it's a produce of the OMC was adopted the recommendation in 2019 on access to social protection for workers and the self-employed. We are in our issue. There is a recall of the social security and social protection of workers, the need of this protection for people in self-employment and on basis of the Article 352. So there is some instruments in EU law, but pointing the respect of national schemes. And in this matter, one time more, it's essential to respect national schemes for each country. So there is an objective, important objective, is the universality of the coverage in respect to the situation of specific groups. The universality of the coverage is in link with the objective of equal treatment between workers, even more widely other people. And to stay in our issue, what is the role of collective bargaining in this project? I think the role of collective bargaining is important. And there is one difficulty, it's like social protection is at national level, and collective bargaining is also very different at each level, and the role of collective bargaining in social protection very, very different in each country. That is a problem of convergence, and there OMC could be an help. But at EU level, it's yet very important in the discussion and proposition from 𝐸tuc and the help of 𝐸tuí. Social partners actually enhance a new directive for the protection of atypical workers, self-employed, especially workers of platforms. So the question of health and security and the matter of social protection must be in there. And perhaps at the EU level, at sectoral level, it could be interesting to have a sector of digital platform. But it's a will. I want to part with you a proposition from a German researcher, Enzo Weber, for that is called digital social security. And in this time of discussion about global agreement for taxes, it's interesting to see. It proposes to systematically tax platforms on the amount of remuneration paid to workers. Thus, all tasks would be taxed, even micro-tasks. The main work as well as the secondary or occasionally activity. And to understand it, you have nice schemes here. So the platform is an intermediary. They said already they are only an intermediary. Intermediary between crowd worker and customers. So the platform paid the crowd workers. So the platform can contribute to a special account or to national social security systems. And the national social security system could coverage the need of the code worker. That seems to be quite simple when one looks at this scheme. But I think it's not so much simple, and I think it's more a dream for the future of social protection. It's interesting, but perhaps for a long-term perspective, because each country must accept and implement such taxes, and that is the huge difficulty. But ILO, EU, and now mondial agreement on platform taxes, all the great social progress began by dreams. Why not one day a mondial agreement on digital social security? Let's keep dream, and I let you to dream. I leave you dream a little more, and I thank you very much for your attention.
Thank you so much, Marie-Cécile. Marie-Cécile said that she's not an expert, but the content of the presentation was like an expert. And now we are going to continue with our second speaker, Gábor Kártyás from Hungary, from the Labor Law Department in Peter Catholic University. Now maybe you are remembered that at the beginning of my presentation today I mentioned the neighbors. Hungary is also a neighbor because it's not a geographical neighbor, but they are in our hearts. Gábor is in Budapest, so the floor is yours there, Gábor.
Thank you very much, and good morning to everyone. And I'd like to greet all the research group members and all our guests here from Budapest, which is not that far, following Daniel's thoughts. And my topic will be today the working time issues of gig economy and how working time can be addressed by collective bargaining agreements. I'd like to ask the technical team to share my PPT slides. I cannot see them already, but I hope you can share it with the group. But nonetheless, until we can see the slides, I like to begin with, oh, thank you, here we go. So, I don't think it needs any more clarification that working time is a very serious issue in collective bargaining agreements. Basically, this is issue number two right after wages. But I often see the claim that in gig economy, working time is not an issue. It's off the table. And this idea is supported by the claim that in gig economy, workers are free to set their own schedules. They can decide how much they want to work, and because of this autonomy they enjoy concerning their working time, these classical protections, classical guarantees of labor law shall not apply here, and it's irrelevant here. Can we move to the next slide, please? But actually, I have serious concerns on this claim whether gig workers, in fact, really enjoy autonomy over their working time, because if it's true, it's just too good to be true for many workers. Like in a strict sense, work time autonomy would mean that the employer guarantees that there is always paid work available whenever the worker decides to log in the application and to take up tasks. Now, practical evidence, empirical evidence supports that this is not the case, at least in the vast majority of the platforms. There are peak seasons for platforms when there are a lot of work available, and there's a high probability that the worker can actually get a task. when he or she is logged in the application, and there are other seasons when there is a much lower chance that actually they can have an assignment. Also, in a strict sense, work time autonomy would mean that the platform has a priority for the workers and not for the clients, and the platform follows the policy that clients can wait, and it's not a problem if the clients cannot have a worker to complete their tasks immediately. Now, I can hardly believe that there is any platform out there who follows this principle. Rather, again, empirical evidence supports that the client is the most important for the platforms, and they would like to sell their service with the idea that whenever you want to have your food delivered to your home by a gig worker, or you want to be given a ride by a driver, then you can get this service in with a very small waiting time. Which on the other hand means that the workers actually are expected to be available as much as they can, and they are expected to accept the tasks and assignments offered to them and not to reject it. Just I like to refer to the Aslam case decided by the Supreme Court in the United Kingdom, where it was expressly referred by the court. Or lastly, if working time autonomy is real, then it means that workers do not have to work excessively long hours to make ends meet, to reach a decent wage, but it's available for them within normal lengths of working time. Now again, with the measure of working time, there are a lot of problems in the gig economy, either because gig workers cannot work enough, they are not offered enough tasks, and they are partly unemployed, basically, or on the other hand, they have to work very long hours to reach an adequate level of remuneration. So all in all, I have serious concerns on this. Basically, my conclusion is that work time autonomy, this full sovereignty over work time is an option only for a handful of gig workers, but most probably not all of them. So work time is in fact an issue in the gig economy as well. Can we move on to the next slide, please? And my other idea why working time is important in the gig economy as well is that this field of labor law, work time regulations, have their roots in occupational safety and health. This is a thought which is continuously referred by the European Court of Justice as well, that these instruments have their roots, have their origin in occupational safety and health. So the basic idea is that workers are human beings, they are Homo sapiens as such. They have biological constraints, they have a health status, and that shall be protected, no matter what is the legal status of the worker, whether he or she is classified as an employee or not. And this applies, of course, for gig workers as well, like food delivery riders have their own health risks which shall be taken into consideration, and the basic instruments of working time, like the maximum level of hourly or daily or weekly working time, or the minimum level of rest periods, are instruments to protect the health of workers, which are to be applied for gig workers as well. Can we move on, please, to the next slide? And even though working time is an issue in gig economy, another question rises: why shall it be regulated by collective agreements? And this is one of the main issues we deal with in this research project. And my answer to this question is that because collective agreements can be the regulatory tools to reach a flexible solution for gig workers, which also guarantees the protection of workers. So this is the tool where the solution, how to apply traditional institutions of working time, is not just mere opt-out, like we won't apply some traditional instruments of working time in this sphere because it's not that easy to adopt these institutions to platform work. But the idea is to offer the possibility of the parties the platforms and their workers to negotiate among themselves and to find their alternative ways how to protect the workers and how to enable the operation of the economic operation of the platform as well. Can we move on, please? And if you see the EU directives on labor law, there are quite many references to the role of collective bargaining agreements. I would tackle these two basic issues. One is that collective agreements can set the details, they can fill the legislative gaps. This is a function which 𝐂𝐨𝐥𝐿 𝐢é𝐺𝐒 mentioned yesterday. And also there are quite many cases in EU law where the directives offer possibilities to deviate from the text of EU law, like not just set the details, but to invent alternative solutions for a given legal problem, and to set this problem in a different way than it is set in the directive by EU law itself. To give you an example, like what are the details which can be set in a collective agreement concerning gig workers, I think the famous phenomenon, the right to disconnect, is a good example here. I don't consider right to disconnect as a legal issue. At least under EU law, it's quite clear that whenever the employee or the worker stands at the disposal of the employer or performs work, it shall be considered working time, even if it is outside the regular business hours. But it is a technical question how to guarantee this right to the employee that outside the regular hours he or she is not ordered to or expected to perform work, like closing down the email servers or send holiday messages and so on. And these technical issues can be very well regulated in collective bargaining agreements. Can we move on, please? And as for the derogations, the main principle in EU labor law is that when EU legislation enables the social partners to deviate from one point of EU law, the main idea is that it cannot be done without proper compensation. So it's not just a mere opt-out, like social partners can agree that they won't apply one or two institutions to the given sector or in the given employer. But the idea is that they may deviate, they may derogate from the statutory law, but they have to offer something in return. They have to offer adequate compensation. This is pretty much clear in Article 18 of the Working Time Directive, but this is not the only place when we have this possibility. I would like to refer to the Agency Work Directive and also the brand new directive on the transparent and predictable working conditions. Also, these directives use this legislative technique that they offer the possibility for the social partners to deviate from the solutions followed by the EU legislator, but they still have to respect the overall protection of workers. So something in return shall be given. It's not just an opt-out. Next slide, please. So far, there's quite limited case law on how to interpret these possibilities, how far social partners can go when they deviate from EU directives like the Working Time Directive. But there are some principles that the European Court of Justice has emphasized so far. For instance, the principle of legal certainty. Because this is very important, because when a collective bargaining agreement deviates from the law, then it is technically substitutes law, then quite obviously it has to be as precise and as clear as we expect it from the law adopted by the parliament or by the national or EU level legislator. So legal certainty is very important in these cases. And also the European Court of Justice ruled that these possibilities are rather exceptions in the body of EU law, so they have to be interpreted in a strict way. Okay, and let's move on. And finally, I'd like to raise your attention that this problem how to adapt working time regulations to the gig economy and whether it is necessary to do so is not just a question for theory and for the labor law scholars, but these questions are actually raised by practice, and they are also answered by the social partners. I collected some of the recent developments in these fields, like such classical problem as the measure of weekly working time was tackled by two collective bargaining agreements, one in Denmark, another one in Austria. Both of them applies to riders, to couriers. Both of them are quite recent, and the importance here is that they try to apply this very traditional labor law protection to this new field. Also, we have a new law in Italy, also on delivery riders. Piera told us about this new piece of legislation yesterday, which also sets some basic remuneration rules concerning special work time periods like night work or weekend work. This is a law, so this is not a collective bargaining agreement, but the law itself encourages social partners to start bargaining processes and to reach collective bargaining agreements and to set the details, further details there. And I'd also like to mention this last collective bargaining agreement from the United Kingdom. This applies to only one platform, but this is very important from the sense that, or from the aspect that it applies to self-employed workers. So this is outside the personal scope of traditional labor law, and it introduces holiday pay, which is again a traditional and very important institution of work time regulations to self-employed workers. So it is very hard to compare these developments. Some of them are law, other ones are sector-level collective bargaining agreements. Some of them apply to employees only, others to self-employed. So there are huge differences among them. But if you see the dates in this slide, it is quite clear that this field developed very quickly. Actually, all of these instruments were adopted in the last 2 years. So I'm sure that in the upcoming years, we will see more and more examples as how social partners or even the national legislator tries to step in and introduce working time regulations even in the gig workers sector. And can we move on, please? Okay, so basically that's all I wanted to tell, and thank you very much for your attention. Thank you.
Thank you so much, Gabor. And now back to the geographical neighbors, because it's waiting Teresa Coelho from the University of Minho. You know that we are here in Galicia. Portugal is our neighbor, and especially is neighbor of Galicia. Teresa, as the rest of our dear colleagues, it's a pity not having you here, but at least we have you online. The floor is yours. I'm not sure if we are listening to you, Teresa. Wait a minute, please.
Are you hearing me?
Now we can hear you. So you.
Sorry. Okay. I was saying thank you very much for your kind words. We are really neighbor, geographically, not only. I'm deeply sorry for not being there with you, but due to last minute problems, I cannot be there. But before I speak about the topic that I'm going to speak about, algorithms, discrimination, and collective bargaining, let me please say that I'm deeply thankful for all the organization, but special to our dear Gemma, Professor José Maria Miranda Boto, and for all the effort to organize this Congress. I know that is very, very, very difficult to organize this kind of Congress. It's very difficult, so stressful, so much work. So thank you very much, Gemma, but also to all the team. I'm deeply thankful also to Yolanda, my dear Yolanda, also to Tanya, also to Lydia, and all the technical team, all the translators, all the invisible team that we don't see, but it is there. So first of all, and okay, I lost 1 or 2 minutes with that, but I had to say that. It's very important. So moving to my topic, can you please, to the next slide, can you move to the next slide, please? Okay, thank you very much. Of course, we live in this, all of you spoke about it yesterday and today also, we live in the digital society and digital work. So they have many opportunities, but also threats and problems. And I think this pandemic situation just showing us even more this kind of problems. So next slide, please. We live really in the age of algorithms, an age of artificial intelligence. And artificial intelligence is not a new phenomenon, but with the digital societies, it really gained a new significance. So we see now the rise of algorithms. So related to algorithms, next slide, please. We have thank you very much. We have the questions of algorithms and the possible discrimination. Because when we thought some years ago, not now, but when we thought about algorithms discrimination, we started to think about mathematical models that could be neutral, could treat everyone equally. But then in reality, we saw that was far away from the truth. And in reality, we had really that algorithms could reinforce discrimination, and by profiling human behavior and with many problems. So in this pandemic situation, and please can we move to the next? Thank you very much. In this pandemic situation, we really saw that. We saw an explosion of the use of algorithm management software. And like it was said by the European Commission, pointed out this in the first phase of the consultation of the social partners on the possible ways to address the challenge related to working platforms, they raised many issues, and one of them was related exactly with algorithm management and the problem of discrimination, the problem of not being in a woman in command approach, and the problem of the lack of predictability, like you see that in work relationships in the end of this. So this is very, very important that we raise these questions because next slide, please. Thank you very much. Because decisions nowadays are increasingly made by these black boxes that we see, and that we see the input, we see the output, but we do not understand many times and the way the algorithm works. And when using algorithms, it's reality. Employers can process large amounts of data in order to obtain relevant information. For example, like you see that can speed up the application process by reading up large number of resumes or analyzing video interviews and selecting the most suitable applicants. They can also distribution of work for workers, to send people out, to dismiss people. And the use of algorithms can streamline this process and may cut costs, since less people are needed for the recruitment and for the assessment of potential employees. However, there is, and in reality that exists, the problem of discrimination. So that is why we reinforce the idea of transparent and algorithms of moving from a kind of black box society to a kind of transparent box society. And this right, moreover, we have to remember, is reinforcing the GDPR, is reinforced that. So and it has to apply to the control performed by the employers, and of course the control performed by the algorithms. So next slide, please. Thank you very much. I think it's important, the Artificial Intelligence Act, this proposal for a regulation that was presented in April this year by the European Union, but when they say specifically about recruitment and they speak about the algorithm using in this part, and also by appointment that is used can be qualified by high risk in this part of recruitment and selection, and it should also be classified, and I'm reading, as high risk, since those systems may appreciable impact future career prospects and livelihoods of this person. So I think this is important. And in Portugal, and next slide please. Sorry, I'm giving you too much work. In Portugal, the Green Paper on the Future of Work 2021 that is going to be presented in a couple of days in the public presented. We are now in the public consultation, and that is going to be public presented on 22th this month, so in a week and 3-4 days from here. We have this issue, that we dealt with this issue, and we have there some lines of reflection for public policies. It's a green paper, it's not a white paper, but we have that lines of reflection, and one of the lines of reflection for public policies is exactly related with transparency of algorithms and even responsibility, not only for the provider, but even in the employer sometimes who buys it and uses it. Another possibility is the existence of external audits. Also, it's very important to see the GDPR. And can we move to the next slide, please? Thank you very much. Recital 71 and Article 22. I think it's very important to highlight mainly this Article 22, and we have already jurisprudence about it in the European Union. Next slide, please. 2 cases in the Netherlands that used Article 22 of GDPR when using algorithm, and they highlight this part of the use of Article 22 to ask a woman to reconsider this decision. So it's important. And the Uber employment case also, they said that the GDPR is the key to avoid the discriminatory consequence of profiling. So I think it's important, this jurisprudence in these cases in the Netherlands. So another point, and related to collective bargaining, moving to the next slide, please, is the Article 88 from GDPR, because it really points out that collective agreements can be considered an important source for ensuring law and lawful and fair and lawful data processing in the context of employment. So moving to collective bargaining and possible contents of collective bargaining. So next slide, please. We really see that social partners can play here a significant role in advancing in this situation by contributing to gender equality, promoting well-being at work, productivity, etc. And considering the wide variety of workplace, of companies, of workers, of employers, of kind of different situations, the best result sometimes can, not always, of course, but can be achieved by tailored measures at work, at enterprise and workplace level, but even sector level also. It's very important. So in Portugal, next slide, please. For example, this law that is very, very recent can be used by social partners in collective agreements, can be used, the part that is here in the article, but that can be more developed in collective agreements. This part, it's the Portuguese Charter of Human Rights in Digital Age. Also, next slide, please. Thank you very much. The Green Paper also has this part, one of the lines of reflection is exactly to encourage the regulation of the use of algorithms in the context of collective bargaining. For example, in the ways to reach each sector. So in collective agreements, next slide, please. Thank you very much. In collective agreements, it could be some contents that we can put it. It could be reinforced the principles that minimize the new risks associated with the autonomous behavior of artificial intelligence, establishing requirements to ensure the protection of privacy and personal data, equality, non-discrimination, ethics, transparency, and explainability. I think this is very important of systems based on algorithms, both in terms of selection of job candidates, but also in terms of execution of employment contract. Also, another possibility is the collective agreements establish the kind and the type of data that could be used in the hiring process, for example, employment relations, having, of course, bearing in mind all the legislation that exists. Another possibility in the collective agreements is to regulate this part, namely in the distribution of tasks, work organization, working time, like Gabor already spoke, social security, like already Marie-Cécile told, health and social security, performance evaluation, progression, and this part. So next slide, please. Thank you very much. Also, it should be emphasized, this, what I said, the kind of data. Also, and this is very, very important, always with the vision that a woman in command approach, always with this vision. And that is what is established in Article 22 of GDPR. In collective agreements also, there should be a part about the consultation of the employers' unions on artificial intelligence system, the establishment of rules about the collecting, the storing, and even sometimes it's necessary to destroy data. And unions should secure fair data collection and evaluation standards. Next slide, please. Thank you very much. And it's interesting to take into account what was the answer of the European Trade Union Confederation on the first phase consultation, because they emphasize the need for collective bargaining at different levels, and one of them was exactly the rules for algorithm. So next slide, and this next slide, please. I'm not going to speak because yesterday Yolanda spoke as well. Always wonderful about this topic, and it's about law, very recent law in Spain. But I think it's very important also, and Yolanda yesterday had already made a frame about it, so I'll skip this part. But I think this is a very interesting point that can be used by trade unions to use this in collective agreements, and may help to diminish the risk of unfair and discriminatory algorithm decision making. And to end, next slide, please. Thank you very much. And in Portugal, I can say that we heard many when we were drafting the green paper, and we had a phase that was exactly related with social partners. We had 1 month of consultation with the social partners at confederation levels, and all social partners really, when they answered about this possibility, all were in favor of discussing this issue of algorithms discrimination as soon as possible. And I put here 3 examples, one from the employer's side, the Portuguese Tourism Confederation, and the 2 others for the workers' side, the two confederations. The first, CGTP, the major workers' confederation in Portugal, and the other, UGT, the other workers' general confederations. They all were in favor of establishing rules about use of algorithms in collective agreements. And they enforce and they emphasize really the idea of participation of social partners, and they reinforce also the part of the involvement of workers' representatives since the beginning. And I think it's important, this part, what I said for the employer side, for the worker side, but this part that UGT said, that the algorithm itself will always be as blind as whoever builds it. And this is very important. So to end up, I think, and to sum up all this, I think it's essential to legislate on this matter, of course, but also to leave to social partners and to collective bargaining the possibility of adoption of more concrete measures to ensure the transparency, the access to information, and to ensure the principles of human dignity, integrity, freedom, privacy, and culture and gender diversity, as well as with fundamental human rights, respecting the right to equality and non-discrimination. Next slide, please. And thank you very much. Muchas gracias. And estoy muy desolada por no poder estar ahí con vosotros. Y muchas gracias. Thank you very much.
Obrigado. Igualmente desolados por no tenerte aquí. Thank you so much. Now it's time for questions and debate. I don't know if there are some questions. Whereas I'm checking the chat, I'm going to ask one first question following the same order that we had in the interventions. Marie-Cécile mentioned the two levels of social protections, the contributory one and the assistance one, and then she proposed a proposal concerning the social protection of digital workers and platform workers. And my question would be if the future of social protection in general and for these kind of workers are more close to the assistance level, the assistance model, or the classical contributory one. What's your opinion?
If they are workers, they don't need the assistance. They don't need the assistance. So for that, I think that a model like this one of Enzo Weber could be really more interesting, because you have in the code work, you have a lot of micro tasks, and you have a lot of workers who are doing that like secondary or very occasional works. And that is completely gray and dark work. The platforms don't pay taxes or contribution on those tasks, and the workers benefit from the coverage of first employment, and the financing is a charge for the principal and transparent employers, and those platforms, they don't contribute. They don't contribute for workers, and they don't, very often, they don't pay taxes in the country where the work is done. So I think contributory taxes perhaps is not the huge problem. The huge problem is how to do for the payment by those platforms. I don't know if it's very clear.
Yes, absolutely. It seems that the questions... there's a question also for Marie-Cécile. Do you think the recent action plan for the implementation of the European Pillar of Social Rights might contribute in a positive way to address the issues you point out?
The proposition from the committee.
Yeah.
I think it's like, although today we are more in soft law than binding law. And that is a more general question for the three presentations. One see that we are really more in political will. So those political will come from EU level, go to the countries, and it's national, and after to the collective bargaining and social partners. So there is like a decentralization of the decisions, and at the end, it's a lot of flexibility. I think so. Perhaps you have your own opinion too.
Thank you so much. I don't know. I have another question, just as we have three topics here. Let's move to working time, but we can go back to social protection if needed. Gabo, yesterday there was little debate here with the Jeremiah's Brussels intervention concerning the waiting periods. Actually, here in Spain, we have one first court judgment setting that when the platform worker login in the platform working time starts, we would like to know your opinion about this debate when the limits of working time in the case of the platform workers.
Well,
Tu micro está apagado.
my concern is that under EU law, it's this very strict binary system that something is either working time or a rest period, and there's nothing in between, is quite useful, and it's quite a lucky situation here when we encounter these situations where it's not that clear whether something is working time or not. We have just these two boxes, and I'm deeply I really support the idea that whenever the employee performs work or at the employer's disposal, it shall be considered working time. But I also accept these experiences from case law that waiting time shall be judged only on a case by case basis, because of course it does matter whether the worker can log on simultaneously to various applications, and so that in that way the worker can be at the disposal of more employers or more platforms at the same time. Of course, that changes the perspective. So if I'm at the disposal of 2 or 3 platforms at the same time, and I'm waiting for tasks coming from 3 different platforms, then I give a good idea or good close to my employers or platforms that to argue that I'm not standing ready for them, because I also look for assignments coming from other platforms. So to sum it up, basically, I think that this strict approach of a binary system is something to be upheld, and it is a value that we should upkeep in the future as well. But a very detailed assessment is needed in every case, so it must be judged on a case-by-case basis whether waiting time is in fact working time. Was I at the disposal of my employer or not?
Excuse me, from your perspective, is there any room for the regulation, I mean the legal regulation or collective bargaining, in order to make it possible with your approach of the case-by-case solution?
Well, if I consider that the reform of the working time directive is on hold for over a decade now, and since the famous decisions concerning the standby duty and on-call duty was not enough to push the legislator to adopt to this new case law and to invent something more modern or more adequate to the present needs. I have concerns whether the right way is to adopt new law on this and decide it on the level of legislation. So I think it is more flexible to have this very broad notions in the legislation, like we have working time and everything else is rest periods, and it is up to the courts and up to the case law to invent in every case what shall be considered as working time and what is a rest period.
Anyway, if there are opinions from the rest of the speakers, despite your topics are very, very different, you can intervene when you want. And now I would like to go to Portugal. And you mentioned the Article 88 from the regulation. And my question is, if we read the article, with that article and collective bargaining would be enough. Do you think that we need a law in the member states level as is happening? You clearly show it in your presentation with real examples such as the one here in Spain.
Thank you very much. And when you were speaking about now to Portugal, I had to say that I remember the European contest of the music, the songs now moving Portugal now in 4 countries. But okay, so Spain 12 points. Okay, so the GDPR. About Article 88, of course, I think, and as there are collective agreements may reinforce this part of algorithms, but I think we have such an Marie-Cécile put a frame different about social security, and when we remember how different are the part of the collective sector and collective bargaining in different countries, sometimes we need a law and then collective agreements to I would say to reinforce or to leave some matters to be developed at the collective bargaining. But I think a law could be a way for it. But then at collective bargaining, they could be more concrete measures about it. I don't know if it was exactly your question, because Article 88 of the GDPR, it's by law or by collective agreements, because we have different traditions at European level. So, for example, here in Portugal, we have a tradition of not plant level, not a plant level, but at sector level. And other countries, it's work level or plant level. So, in a way, I think we had a law and then a development at the collective bargaining. And I have to say that, at least in the case of Portugal, all social partners were in favor of having rules in collective bargaining about it.
And is collective bargaining at national level innovative enough to develop this kind of so technical rules to regulate the algorithms?
Yeah, that's a very interesting question. I think the dream, and I'm going to dream, like I already spoken about it. I'm going to dream. I think it would be much better if we had not at the national level, but at supranational level. But it's very, very difficult, but it will be ideal. But we have to see that could be different from the kind of crowd work that we have, for example, of the kind of algorithms that we can use. For example, here in Portugal, we have now a problem related to algorithms that I could not spoke about it because it's not collective agreement, but we have an algorithm in dismissal of the TAP, our transport sector, in the transport sector, and we had an algorithm that was used in the dismissal of employees, and it was a very, very difficult issue because employees didn't know the content of the algorithm, how the algorithm decided. They weren't informed. So that's why I think the law that you had now that amended your Estatuto de los Trabajadores about the right to information, it's quite important to have this. So at law level and at a collective agreement. But the ideal will be maybe at a supranational level. But let's start with little, and at national level, and then try to have a supranational level. I think it should be. Let's keep dreaming.
Thank you so much. I'm checking if there are other questions on the chat. It seems that there are no more questions, so I'm going to give you the floor, just the last round, in case you want to add anything else or explain anything else, or just to go into the other issues that your colleagues treated. Marie-Cécile, you are the first one.
Perhaps a general question. about collective bargaining. Because, like I said, we see that the level is lower, decentralized, but for more flexibility. It's the title of the presentation of Gabor. But flexibility in a lower protection, it seems so. And if we are going from binding and from political to bargaining, the problem is the force, the stronger of the partners. And I don't know if there are very stronger partners in from the trade unions in Portugal or in Hungary. But in France, actually, the trade unions are not very strong. And French law don't help them because there are a lot of laws that is, oh, if there are no trade union, you can have social dialogue with other representatives, more or less representative. So I think that there is a danger for the protection of the workers with this decentralization and weakness of the partners, but the partners by the side of the workers. And other reflection in this collective bargaining is that we are speaking about workers who are alone. We are not in the context of the industrial legislation and in the industrial revolution. Well, there was the collective was something. There was 100,000 of workers working in the mine, in the factory, and today everyone is front of the screen of his laptop. So they are working in their room for micro tasks, or they are driving alone or cycling alone, and it's very difficult to create collective. So speaking about collective bargaining, my reflection is how to recreate a strong collective by digital platform. I think so, but to recreate this collective, to have bargaining and real bargaining, stronger bargaining.
Exactly, that's a trend which is not only characterizing the platform work, but in general all kind of negotiations, because the possibility of negotiating with in micro companies with no unionized employees have been promoted by the European Commissions in countries such as Portugal or here in Spain. I would like to know your opinions, Gabor, Teresa. Whoever you want.
No, I can say, but if Gabor spoke a second, I thought it will be you'd speak, but I can speak. I don't know. Gabor, do you want, or can I?
Please go first.
Okay, thank you. Ladies first. Okay, thank you, Gabor. No, I totally agree with what Marie-Cécile spoke. This is the real challenge, because the isolation, as you say, they cycle alone, they drive alone, they work alone in front of a laptop, and really they are weak. If they want to negotiate, if they want to how can they negotiate if they are alone in a world, totally alone, and they are very weak partners. So to create and to negotiate, we have to try to create incentives for unionize these And this is very, very difficult, but not only in digital world, as Daniel already spoke about it. We had that in problems since many, 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 many years, since I remember. We have what we call sometimes unions that are very, very, very weak. They don't have workers, and not many times before speaking about digital platforms and in digital work. And digital work, I think, just showing us even more. And this pandemic situation just showing us even more how isolated we are in many situations. So it's really, really a problem. And that's why I said by law sometimes, and then if we can, then go to collective bargaining, if possible, I think. But I totally agree with what Marie-Cécile told. And thank you very much, Marie-Cécile, for saying that. Merci beaucoup. Now,
Gabor?
I agree that it's a very important topic, and thank you, Marie-Cécile, that you brought it up. I think Hungary is a good illustration for this problem. That if you read the text of the Hungarian labor code, you will have the impression that Hungary is the heaven of social bargaining and trade unions and collective bargaining agreements, because the law itself gives a huge possibility for the social partners to agree upon working conditions and to deviate from the statutory law. And also the representation level which is required for a trade union to start or to conclude a collective bargaining agreement is very low. But in practice, we have a very, very limited coverage of collective bargaining agreements, not in gig economy, but in the traditional industrialized sectors also. So the question is really what aims and what purpose collective bargaining can have if trade unions are very weak. So this is the reality in Hungary, and we very often face this question, again, not only in gig economy, but also in the most traditional old-fashioned sectors of industry as well. So, but I can again connect back to you, Marie-Cécile, that you finished your presentation that maybe we are in the phase of dreaming in many problems concerning labor law, and this is something similar that I don't know, I can't solve this problem in 2 minutes. That's how could we change this situation and how could we empower trade unions? One thing is sure, that's not only a legal problem. So in Hungary, I think the laws give all the powers to trade unions to go out on the field and start building, but it's just not happening. It must have other reasons, not just legal issues out there. Thank you.
Thank you so much. If there are no more comments, I think that we can close the session with this last reflections. Thank you, dear speakers, for your marvelous presentations. And for the audience, we'll see you at 11:30, so around 30 minutes to continue debating and the reflection.